Ladies and gentlemen, what's been handed out to you now are copies of the instructions that I'm about to read to you. This is to assist you in following along and understanding what's being read to you. Don't worry about trying to memorize anything. You'll be taking these instructions back to the jury room with you, and you can refer to them back here. The arguments have been lengthy, and this is going to be somewhat lengthy. Does anyone need a comfort break at this point? Okay. All right. Here we go. Members of the jury, the evidence in this case has been completed, and it is my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of others, but should consider each one in light of and in harmony with the others. Whenever the singular of a word is used in these instructions, it may be taken equally to mean the plural. Whenever the word he is used in these instructions, you may consider it as applying equally to a woman. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks which I have made, do I mean to indicate any opinion as to the facts or as to what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. You must not consider for any purpose any offer of evidence that was rejected, or any evidence that was stricken out by the court. Such matter is to be treated as though you had never known it. You must never speculate to be true any insinuation suggested by a question asked the witness. A question is not evidence and may be considered only as it supplies meaning to the answer. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all of the evidence in the light of your own observations and experience in life. You, as jurors, must decide this case based solely on the evidence presented here within the four walls of this courtroom. This means that during the trial, you must not conduct any independent research about this case, the matters in the case, and the individuals involved in the case. In other words, you should not consult any dictionaries or reference materials, search the internet, websites, blogs, or use any other electronic tools to obtain information about this case or to help you decide the case. Please do not try to find out information from any source outside the confines of this courtroom. Until you retire to deliberate, you must not discuss this case with anyone, even your fellow jurors. After you retire to deliberate, you may begin discussing the case with your fellow jurors, but you cannot discuss the case with anyone else until you have returned a verdict and the case is at an end. I hope that for all of you, this case is interesting and noteworthy. I know that many of you use cell phones, Blackberries, the internet, or other tools of technology. You also must not talk to anyone about this case or use these tools to communicate electronically with anyone about the case. This includes your family and friends. You may not communicate with anyone about the case on your cell phone, through email, Blackberry, smartphone, text messaging, or on Twitter, through any blog or website, through any internet chat room, or by way of any other social networking websites, including but not limited to Facebook, Snapchat, Instagram, LinkedIn, and YouTube. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless, from all the evidence in the case, you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts, but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all the truth in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required. And this certainty is required as to every element of proof necessary to constitute the offense. The state must have proven beyond a reasonable doubt all of the elements of the crime charged and that it was committed before the finding and returning of the indictment in this case. The defendant, Eric Boyd, is charged in the presentment with the crimes of first-degree murder, especially aggravated robbery, especially aggravated kidnapping, and aggravated rape. The presentment in this case charges a total of 12 offenses related to 2 victims. Several of these offenses are charged in separate counts of the presentment under alternative theories. The 10 charged offenses are: 1. First-degree murder of Hugh Christopher Newsom. 8 counts felony murder and 1 count premeditated murder. 2. First-degree murder of Shannon Christian. 8 counts felony murder and 1 count premeditated murder. 3. Especially aggravated robbery of Hugh Christopher Newsom. 4. Especially aggravated robbery of Shannon Christian. 5. Especially aggravated kidnapping of Hugh Christopher Newsom. 2 counts. 6. Especially aggravated kidnapping of Shannon Christian. 2 counts. 7. Aggravated rape by anal penetration of Hugh Christopher Newsom. 3 counts. 8. Aggravated rape by anal penetration of Shannon Christian. 3 counts. 9. Aggravated rape by oral penetration of Shannon Christian. 3 counts. And 10. Aggravated rape by vaginal penetration of Shannon Christian. 3 counts. Each of these offenses necessarily includes lesser offenses which are listed more specifically herein. In counts 1, 2, 5, 6, 9, 10, 13, and 14 of the presentment in this case charge the defendant, Eric Boyd, with the offense of first-degree felony murder upon the alleged victim, Hugh Christopher Newsom, by alternative theories. Counts 3, 4, 7, 8, 11, 12, 15, and 16 of the presentment in this case charge the defendant, Eric Boyd, with the offense of first-degree felony murder upon the alleged victim, Shannon Christian, by alternative theories. The offense of first-degree felony murder necessarily includes the lesser offenses of facilitation of first-degree felony murder, second-degree murder, facilitation of second-degree murder, reckless homicide, facilitation of reckless homicide, and criminally negligent homicide. Count 17 of the presentment in this case alternatively charges the defendant, Eric Boyd, with the offense of first-degree premeditated murder upon the alleged victim, Hugh Christopher Newsom. Count 18 of the presentment in this case alternatively charges the defendant, Eric Boyd, with the offense of premeditated first-degree murder upon the alleged victim, Shannon Christian. The offense of premeditated first-degree murder necessarily includes the lesser offenses of facilitation of premeditated first-degree murder, second-degree murder, facilitation of second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, reckless homicide, facilitation of reckless homicide, and criminally negligent homicide. Count 19 of the presentment in this case charges the defendant, Eric Boyd, with the offense of especially aggravated robbery of the alleged victim, Hugh Christopher Newsom. Count 20 of the presentment in this case charges the defendant, Eric Boyd, with the offense of especially aggravated robbery of the alleged victim, Shannon Christian. The offense of especially aggravated robbery necessarily includes the lesser offenses of facilitation of especially aggravated robbery, aggravated robbery, facilitation of aggravated robbery, robbery, facilitation of robbery, aggravated assault, facilitation of aggravated assault, theft, and assault. Counts 21 and 22 of the presentment in this case charge the defendant, Eric Boyd, with the offense of especially aggravated kidnapping upon the alleged victim, Hugh Christopher Newsom, by alternative means. Counts 23 and 24 of the presentment in this case charge the defendant, Eric Boyd, with the offense of especially aggravated kidnapping upon the alleged victim, Shannon Christian, by alternative means. The offense of especially aggravated kidnapping necessarily includes the lesser offenses of facilitation of especially aggravated kidnapping, aggravated kidnapping, facilitation of aggravated kidnapping, kidnapping, facilitation of kidnapping, false imprisonment, and facilitation of false imprisonment. Counts 25, 26, and 27 of the presentment in this case charge the defendant, Eric Boyd, with the offense of aggravated rape upon the alleged victim, Hugh Christopher Newsom, by alternative means. Counts 28 through 36 of the presentment in this case charge the defendant, Eric Boyd, with 3 separate offenses of aggravated rape upon the alleged victim, Shannon Christian. Counts 28, 31, and 34 charge the offense of aggravated rape of Shannon Christian by anal penetration. Counts 29, 32, and 35 charge the offense of aggravated rape of Shannon Christian by oral penetration. Counts 30, 33, and 36 charge the offense of aggravated rape by Shannon Christian, of Shannon Christian by vaginal penetration. Each of the 3 separate offenses is charged by alternative means. The offense of aggravated rape necessarily includes the lesser offenses of facilitation of aggravated rape, facilitation of rape, aggravated sexual battery, facilitation of aggravated sexual battery, and facilitation of sexual battery. The verdict forms provided to you with these instructions, and which will be read and provided to you, include the specific victim and the specific charges alleged for each offense, as charged in the presentment. The presentment in this case is the formal written accusation charging the defendant with these crimes. It is not evidence against the defendant and does not create any inference of guilt. The defendant pleads not guilty to each and every offense embraced in the presentment. Criminal responsibility. Under the doctrine of criminal responsibility, a defendant is criminally responsible as a party to the offenses charged in the presentment. First-degree felony murder, premeditated first-degree murder, especially aggravated kidnapping, especially aggravated robbery, and aggravated rape, as well as their lesser included offenses, if the offenses were committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the offense. A defendant who is criminally responsible for an offense may be found guilty not only of that offense, but also for any other offense or offenses committed by another, if you find beyond a reasonable doubt that the other offense or offenses committed were natural and probable consequences of the original offense for which the defendant is found criminally responsible, and that the elements of the other offense or offenses that accompanied the original offense have been proven beyond a reasonable doubt. With regard to counts 1 through 16, charging the defendant with murder in the perpetration of a robbery, kidnapping, rape, or theft, this natural and probable consequences rule does not apply. There is no requirement that the killing be foreseeable in order to hold the defendant criminally responsible, only that the defendant intended to commit the robbery, kidnapping, rape, or theft. In deciding the criminal responsibility of the defendant, the jury may also take into consideration any evidence offered that the defendant attempted to thwart or withdraw from any of the offenses that followed from the original offense. To find a defendant criminally responsible for the acts of another, it is not necessary that you find the defendant was present or that the defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of the offense is not sufficient to support a conviction. Before you find the defendant guilty of being criminally responsible for said offenses committed by the conduct of another, you must find that all the essential elements of said offenses have been proven by the state beyond a reasonable doubt. It is not a defense that the person for whose conduct the defendant is criminally responsible has been convicted or has been convicted of a different offense. Facilitation of a felony. Any person who commits the offense of facilitation of a felony is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit the specific felony, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense. And 2, that the defendant furnished substantial assistance to that person in the commission of the specific felony. And 3, that the defendant furnished such assistance knowingly. Intent, as used above, means that a person acts intentionally with respect to the nature of the conduct and to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct and cause the result. Knowingly, as used above, means that a person acts knowingly when the person is aware of the particular nature of the conduct and that the particular circumstances exist and that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Facilitation of a felony is part of the lesser included offenses in counts 1 through 36. Please refer to this definition as directed under each of those counts and their lesser included accounts. First-degree felony murder. Any person who commits first-degree felony murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant, or one for whom the defendant is criminally responsible, unlawfully kills the alleged victim. And 2, that the killing was committed in the perpetration of the alleged specific felony or theft. That is, that the killing was closely connected to the specific alleged felony or theft and was not a separate, distinct, and independent event. And 3, that the defendant intended to commit the specific alleged felony or theft. As previously stated, the alleged victim in counts 1, 2, 5, 6, 9, 10, 13, and 14 is Hugh Christopher Newsom. The alleged specific felony or theft as described above in each of these counts is as follows. Count 1, robbery of Hugh Christopher Newsom. Count 2, robbery of Shannon Christian. Count 5, kidnapping of Hugh Christian Newsom. Count 6, kidnapping of Shannon Christian. Count 9, rape of Hugh Christian Newsom. Count 10, rape of Shannon Christian. Count 13, theft of property of Hugh Christopher Newsom. And 14, theft of property of Shannon Christian. As previously stated, the alleged victim in counts 3, 4, 7, 8, 11, 12, 15, and 16 is Shannon Christian. The alleged specific felony or theft as described above in each of these counts is as follows. Count 3, robbery of Hugh Christopher Newsom. Count 4, robbery of Shannon Christian. Count 7, kidnapping of Hugh Christopher Newsom. Count 8, kidnapping of Shannon Christian. Count 11, rape of Hugh Christopher Newsom. Count 12, rape of Shannon Christian. Count 15, theft of property of Hugh Christopher Newsom. And count 16, theft of property of Shannon Christian. The specific elements of the offenses of robbery, kidnapping, rape, and theft have been set forth below in these instructions and will be read to you and should be referred to here. The intent to commit the specific underlying felony or theft must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony or theft existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the specific alleged felony or theft. The killing may precede, coincide with, or follow the specific alleged felony or theft and still be considered as occurring in the perpetration of the specific alleged felony or theft so long as there is a connection in time, place, and continuity of action. When one enters into a scheme with another to commit a specific enumerated felony or theft and death ensues, all defendants are responsible for the death regardless of who actually committed the killing and whether the killing was specifically contemplated by the other. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious, objective, or desire to engage in the conduct or cause the result. If you find from the proof beyond a reasonable doubt that the defendant is guilty of felony murder in the first degree, you will so report, and your verdict in that event shall be that you, the jury, find the defendant guilty of first-degree felony murder. If you have a reasonable doubt as to the defendant's guilt of first-degree felony murder as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of first-degree felony murder, a lesser included offense. Facilitation of first-degree felony murder. The essential elements necessary to constitute facilitation of a felony and first-degree felony murder have been previously set out in these instructions. Please refer to those instructions here. If you have a reasonable doubt as to the defendant's guilt of facilitation of first-degree felony murder as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of second-degree murder, a lesser included offense. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of second-degree murder, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted knowingly. Here, knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Here, intentionally means that a person acts intentionally when it is the person's conscious, objective, or desire to cause the death of the alleged victim. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a responsible person to act in an irrational manner. If you have a reasonable doubt as to the defendant's guilt of second-degree murder as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of second-degree murder, a lesser included offense. Facilitation of second-degree murder. Facilitation of a felony and second-degree murder. Facilitation of a felony and second-degree murder have been previously defined for you above in these instructions, and those instructions should be referred to here. If you have a reasonable doubt as to the defendant's guilt of facilitation of second-degree murder as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of reckless homicide, a lesser included offense. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of reckless homicide, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim, and 2, that the defendant acted recklessly. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. The terms intentionally and knowingly have been previously defined for you in the elements of second-degree murder. Please refer to those definitions here. If you have a reasonable doubt as to the defendant's guilt of reckless homicide as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of reckless homicide, a lesser included offense. Facilitation of reckless homicide. Facilitation of a felony and reckless homicide have been previously defined for you above in these instructions, and those instructions should be referred to here. If you have a reasonable doubt as to the defendant's guilt of facilitation of reckless homicide as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of criminally negligent homicide, a lesser included offense. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of criminally negligent homicide, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim, and 2, that the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly. Definitions for the terms intentionally, knowingly, and recklessly were provided for you in the court's definitions of the elements of reckless homicide and second-degree murder. Please refer to those definitions here. If you have a reasonable doubt as to the defendant's guilt of criminally negligent homicide as charged in the presentment, then your verdict must be not guilty as to this offense. Premeditated first-degree murder. Any person who commits the offense of premeditated first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. And 3, that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. As previously indicated, count 17 of the presentment in this case charges the defendant, Eric Boyd, with the offense of premeditated first-degree murder upon the alleged victim, Hugh Christopher Newsom. Count 18 of the presentment in this case charges the defendant, Eric Boyd, with the offense of premeditated first-degree murder upon the alleged victim, Shannon Christian. If you find from the proof beyond a reasonable doubt that the defendant is guilty of premeditated murder in the first degree, you will so report, and your verdict in that event shall be that you, the jury, find the defendant guilty of premeditated first-degree murder. If you have a reasonable doubt as to the defendant's guilt of premeditated first-degree murder as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of premeditated first-degree murder, a lesser-included offense. Facilitation of a felony and premeditated first-degree murder have been previously defined for you above in these instructions, and those instructions should be referred to here. If you have a reasonable doubt as to the defendant's guilt of facilitation of premeditated first-degree murder as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of second-degree murder, a lesser-included offense. Second-degree murder has been previously defined for you above in these instructions, and those instructions should be referred to here. If you have a reasonable doubt as to the defendant's guilt of second-degree murder as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of second-degree murder, a lesser-included offense. Facilitation of a felony and second-degree murder have been previously defined for you above in these instructions, and those instructions should be referred to here. If you have a reasonable doubt as to the defendant's guilt of facilitation of second-degree murder as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of voluntary manslaughter, a lesser-included offense. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation, sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The terms intentionally and knowingly have been previously defined for you in the elements of second-degree murder. Please refer to those definitions here. If you have a reasonable doubt as to the defendant's guilt of voluntary manslaughter as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of voluntary manslaughter, a lesser included offense. Facilitation of a felony and voluntary manslaughter have been previously defined for you above in these instructions, and those instructions should be referred to here. If you have a reasonable doubt as to the defendant's guilt of facilitation of voluntary manslaughter as charged in the presentment, then your verdict must be not guilty as to the offense, and then you shall proceed to determine his guilt or innocence of reckless homicide, a lesser included offense. Reckless homicide has been previously defined for you above in these instructions, and those instructions should be referred to here. If you have a reasonable doubt as to the defendant's guilt of reckless homicide as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of reckless homicide, a lesser included offense. Facilitation of a felony and reckless homicide has been previously defined for you in these instructions, and those instructions should be referred to here. If you have a reasonable doubt as to the defendant's guilt of facilitation of reckless homicide as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of criminally negligent homicide, a lesser included offense. Criminally negligent homicide has been previously defined for you above in these instructions, and those instructions should be referred to here. If you have a reasonable doubt as to the defendant's guilt of criminally negligent homicide as charged in the presentment, then your verdict must be not guilty as to this offense, especially aggravated robbery. Any person who commits this offense is guilty of a crime. For you to find the defendant guilty of especially aggravated robbery, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly obtained or exercised control over property owned by the alleged victim, and 2, that the defendant did not have the owner's effective consent, and 3, that the defendant intended to deprive the owner of the property, and 4, that the defendant took such property from the person of another by the use of violence or by putting the person in fear, and 5, that the defendant took such property intentionally or knowingly, and 6, that the defendant accomplished this act with a deadly weapon, and 7, that the alleged victim suffered serious bodily injury. As previously indicated, count 19 of the presentment in this case charges the defendant, Eric Boyd, with the offense of especially aggravated robbery upon the alleged victim, Hugh Christopher Newsom. Count 19 alleges that the property owned by the alleged victim, Hugh Christopher Newsom, which the defendant knowingly obtained control over, was car keys, driver's license, hat, shoes, and other items. Count 20 of the presentment in this case charges the defendant, Eric Boyd, with the offense of especially aggravated robbery upon the alleged victim, Shannon Christian. Count 20 alleges that the property owned by the alleged victim, Shannon Christian, which the defendant knowingly obtained control over, was a Toyota 4Runner vehicle, purse, shoes, clothing, and other items. The fear constituting an element of robbery is fear of present personal peril from violence, offered or intended. Resistance of the party robbed is not required. The taking from the person may be actual or constructive. It is actual when the taking is immediately from the person, and constructive when in the possession of the person or in the person's presence. The alleged fear or violence used in the taking of the property must precede, accompany, or occur at the same time as the taking to constitute an element of especially aggravated robbery. Obtain means to bring about a transfer or purported transfer of property or of a legally recognized interest therein, whether to the defendant or another. Obtain includes, but is not limited to, the taking, carrying away, or the sale, conveyance, or transfer of title to, or interest in, or possession of property. Exercise control over property is defined as the right to direct how property, real or personal, shall be used or disposed. Generally, one must possess the right of possession in property in order to exercise control over it. Such possession may be actual or constructive, sole or joint. Also, one may have the right to control property without having a possessory interest. In such instances, if the defendant takes some action with the intent to deprive the owner of the property, and the defendant did so knowingly and without the owner's effective consent, the jury would be justified in returning a verdict of guilty. Anyone who is in a position to take some action that deprives the owner of property is in a position to control property. Property means anything of value, including but not limited to money or tangible or intangible personal property. Owner means a person other than the defendant who has possession of or any interest other than a mortgage, deed of trust, or security interest in property, even though that possession or interest is unlawful, and without whose consent the defendant has no authority to exert control over the property. Effective consent means assent in fact, whether express or apparent, including assent by one legally authorized to act for another. Consent is not effective when induced by deception or coercion. Deprive means to withhold property from the owner permanently, or for such a period of time as to substantially diminish the value or the enjoyment of the property to the owner. Here, intentionally means that a person acts intentionally with respect to the nature of the conduct and to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct and cause the result. Here, knowingly means that a person acts knowingly when the person is aware that her conduct is of a particular nature and that a particular circumstance exists and that the conduct was reasonably certain to cause the result. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Serious bodily injury means bodily injury which involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, physical pain, or temporary illness, or impairment of the function of a bodily member, organ, or mental faculty. Violence means evidence of physical force unlawfully exercised so as to damage, injure, or abuse. Physical contact is not required to prove violence. Unlawfully pointing a deadly weapon at an alleged victim is physical force directed toward the body of the victim. If you have a reasonable doubt as to the defendant's guilt of especially aggravated robbery as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of especially aggravated robbery, a lesser included offense. Facilitation of a felony and especially aggravated robbery have been previously defined for you above in these instructions, and those instructions should be referred to here. If you have a reasonable doubt as to the defendant's guilt of facilitation of especially aggravated robbery as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of aggravated robbery, a lesser included offense. Any person who commits the offense of aggravated robbery is guilty of a crime. For you to find the defendant guilty of aggravated robbery, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly obtained or exercised control over property owned by the alleged victim. And 2, that the defendant did not have the owner's effective consent. And 3, that the defendant intended to deprive the owner of the property. And 4, that the defendant took such property from the person of another by the use of violence or by putting the person in fear. And 5, that the defendant took such property intentionally or knowingly. And 6, A, that the defendant accomplished this act with a deadly weapon. Or B, that the alleged victim suffered serious bodily injury. The fear constituting an element of robbery is fear of present personal peril from violence offered or impending. Resistance of the party robbed is not required. The taking from the person may be actual or constructive. It is actual when the taking is immediately from the person, and constructive when in the possession of the person or in the person's presence. The alleged fear or violence used in the taking of the property must precede, accompany, or occur at the same time as the taking to constitute an element of especially aggravated robbery. Definitions for the terms obtain, exercise control over property, owner, effective consent, deprive, deadly weapon, serious bodily injury, violence, intentionally and knowingly were provided for you in the court's definitions of the elements of especially aggravated robbery. Please refer to those definitions here. If you have a reasonable doubt as to the defendant's guilt of aggravated robbery as charged in the presentment, then your verdict must be not guilty to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of aggravated robbery, a lesser included offense. Facilitation of a felony and aggravated robbery has been previously defined for you above in these instructions, and those instructions should be referred to here. If you have a reasonable doubt as to the defendant's guilt of facilitation of aggravated robbery as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of robbery, a lesser included offense. Robbery. Any person who commits the offense of robbery is guilty of a crime. For you to find the defendant guilty of robbery, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly obtained or exercised control over property owned by the alleged victim. And 2, that the defendant did not have the owner's effective consent. 3, that the defendant intended to deprive the owner of the property. And 4, that the defendant took such property from the person of another by the use of violence or by putting the person in fear. And 5, that the defendant took such property intentionally or knowingly. The fear constituting an element of robbery is fear of present personal peril from violence offered or intended. Resistance of the party robbed is not required. The taking from the person may be actual or constructive. It is actual when the taking is immediately from the person, and constructive when in the possession of the person or in the person's presence. The alleged fear or violence used in the taking of the property must precede, accompany, or occur at the same time as the taking to constitute an element of especially aggravated robbery. Definitions for the terms obtain, exercise control over property, owner, effective consent, deprive, violence, intentionally, and knowingly were provided for you in the court's definitions of the elements of especially aggravated robbery. Please refer to those definitions here. If you have a reasonable doubt as to the defendant's guilt of robbery as charged in the presentment, then your verdict must be not guilty as to this offense. And then you shall proceed to determine his guilt or innocence of facilitation of robbery. Facilitation of a felony and robbery have been previously defined for you above in these instructions, and those instructions should be referred to here. If you have a reasonable doubt as to the defendant's guilt of facilitation of robbery as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of intentional or knowing aggravated assault, a lesser included offense. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find the defendant guilty of the intentional or knowing aggravated assault, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intentionally or knowingly caused another to reasonably fear imminent bodily injury, and 2, that the defendant caused serious bodily injury to another, or B, that the defendant used or displayed a deadly weapon. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Definitions for the terms bodily injury, serious bodily injury, deadly weapon, intentionally, knowingly, and knowingly were provided for you in the court's definitions of the elements of especially aggravated robbery. Please refer to those definitions here. If you have a reasonable doubt as to the defendant's guilt of intentional or knowing aggravated assault as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of intentional or knowing aggravated assault, a lesser included offense. Facilitation of a felony and intentional or knowing aggravated assault have been previously defined for you above in these instructions, and those instructions should be referred to here. If you have a reasonable doubt as to the defendant's guilt of facilitation of intentional or knowing aggravated assault as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of reckless aggravated assault, a lesser included offense. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find the defendant guilty of reckless aggravated assault, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant recklessly caused bodily injury to another, and 2A, that such bodily injury was serious, or B, that the defendant used or displayed a deadly weapon. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct and the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the certain circumstances exist and the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances, as viewed from the accused person's standpoint. The requirement of recklessness is also established if it is shown that the defendant acted knowingly or intentionally. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Definitions for the terms bodily injury, serious bodily injury, deadly weapon, intentionally, and knowingly were provided for you in the court's definition of the elements of especially aggravated robbery. Please refer to those definitions here. If you have a reasonable doubt as to the defendant's guilt of reckless aggravated assault as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of reckless aggravated assault, a lesser included offense. Facilitation of a felony and reckless aggravated assault have been previously defined for you above in these instructions, and those instructions should be referred to here. If you have a reasonable doubt as to the defendant's guilt of facilitation of reckless aggravated assault as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of theft of property, a lesser included offense. Any person who commits the offense of theft of property is guilty of a crime. For you to find the defendant guilty of theft of property, the state must have proven beyond a reasonable doubt the existence of the following elements. 1, that the defendant knowingly obtained or exercised control over property owned by the alleged victim, and 2, that the defendant did not have the owner's effective consent, and 3, that the defendant intended to deprive the owner of the property. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Definitions for the terms obtain, exercise control over property, property, owner, effective consent, intentionally and knowingly were provided for you in the court's definitions of the elements of especially aggravated robbery. Please refer to those definitions here. Deception occurs when a person knowingly A, creates or reinforces a false impression by words or conduct, including false impressions of fact, law, value, or intention, or other state of mind that the person does not believe to be true. Or B, prevents another from acquiring information which would likely affect the other's judgment in the transaction. Or C, fails to correct a false impression of law or fact the person knows to be false, and one that the person created or who knows is likely to influence another. D, fails to disclose a lien, security interest, adverse claim, or other legal impediment to the enjoyment of the property, whether the impediment is or is not valid, or is not a matter of public record, or E, employs any other scheme to defraud, or F, promises performance which at the time the person knows he or she does not have the ability to perform, or which the person does not intend to perform, or knows will not be performed, except mere failure to perform is insufficient to establish that the person did not intend to perform, or knew the promise would not be performed. Promising performance includes issuing a check or similar side order for the payment of money or use of a credit or debit card when the person knows the check, side order, or credit or debit slip will not be honored for any reason. Deception does not include falsity as to matters having no pecuniary significance, or puffing by statements unlikely to deceive ordinary persons in a group address. Here, coercion means a threat, however communicated, to A, commit any offense, or B, wrongfully accuse any person of any offense, or C, expose any person to hatred, contempt, or ridicule, or D, harm the credit or business repute of any person, or E, take or withhold action as a public servant, or cause a public servant to take or withhold action. Deprive means A, to withhold property from the owner permanently or for such a period of time as to substantially diminish the value or enjoyment of the property to the owner, or B, to withhold property or cause it to be withheld for the purpose of restoring it only upon payment of a reward or other compensation, or C, to dispose of property or use or transfer any interest in it under circumstances that make its restoration unlikely. If you have a reasonable doubt as to the defendant's guilt of theft of property as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of assault, a lesser included offense. Any person who commits an assault upon another is guilty of a crime. For you to find the defendant guilty of assault, the state must have proven beyond a reasonable doubt the existence of the following essential elements. Part A, 1, that the defendant caused bodily injury to another, and 2, that the defendant acted either intentionally, knowingly, or recklessly, or Part B, that the defendant caused another to be in reasonable fear of imminent bodily injury, and 2, that the defendant acted either intentionally or knowingly. Definitions for the terms intentionally, knowingly, recklessly, and bodily injury were provided for you in the court's definition of the elements of especially aggravated robbery and reckless aggravated assault. Please refer to those definitions here. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. The requirement of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. If you have a reasonable doubt as to the defendant's guilt of assault as charged in the presentment, then your verdict must be not guilty as to this offense. especially aggravated kidnapping. Any person who commits an especially aggravated kidnapping is guilty of a crime. As previously stated, counts 21 and 22 of the presentment in this case charges the defendant, Eric Boyd, with the offense of especially aggravated kidnapping upon the alleged victim, Hugh Christopher Newsom, by alternative means. Counts 23 and 24 of the presentment in this case charges the defendant, Eric Boyd, with the offense of especially aggravated kidnapping upon the alleged victim, Shannon Christian, by alternative means. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly removed or confined another unlawfully so as to interfere substantially with the other person's liberty. And 2A, that the confinement or removal was accomplished with a deadly weapon, it counts 21 and 23, or B, that the alleged victim suffered serious bodily injury, counts 22 and 24. A removal or confinement is unlawful if it is accomplished by force, threat, or fraud. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything within the manner of its use or intended use is capable of causing death or serious bodily injury. Force means compulsion by the use of physical power or violence. Violence means evidence of physical force unlawfully exercised so as to damage, injure, or abuse. Physical contact is not required to prove violence. Unlawfully pointing a deadly weapon at an alleged victim is physical force directed toward the body of the victim. Fraud is defined as the term is used in ordinary conversation and includes but is not limited to deceit, trickery, misrepresentation, and subterfuge. Serious bodily injury means bodily injury which involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty. Here, knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Here, intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. If you have a reasonable doubt as to the defendant's guilt of especially aggravated kidnapping as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of especially aggravated kidnapping, a lesser included offense. Facilitation of a felony and especially aggravated kidnapping has been previously defined for you above in these instructions, and those instructions should be referred to here. If you have a reasonable doubt as to the defendant's guilt of facilitation of especially aggravated kidnapping as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of aggravated kidnapping, a lesser included offense. Any person who commits the offense of aggravated kidnapping is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly removed or confined another unlawfully so as to interfere substantially with the other's liberty. And 2A, that the defendant possessed or threatened the use of a deadly weapon in counts 21 and 23. Or B, that the alleged victim suffered bodily injury in counts 22 and 24. Definitions for the terms unlawful removal or confinement, deadly weapon, force, violence, fraud, knowingly, and intentionally were provided for you in the court's definitions of the elements of especially aggravated kidnapping. Please refer to those definitions here. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. If you have a reasonable doubt as to the defendant's guilt of aggravated kidnapping as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of aggravated kidnapping, a lesser included offense. Facilitation of a felony and aggravated kidnapping have been previously defined for you above in these instructions, and those instructions should be referred to here. If you have a reasonable doubt as to the defendant's guilt of facilitation of aggravated kidnapping as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of kidnapping, a lesser included offense. Any person who commits the offense of kidnapping is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly removed or confined another unlawfully so as to interfere substantially with the other's liberty. And 2, that the removal or confinement was under circumstances that exposed the other to substantial risk of bodily injury. Definitions for the terms unlawful removal or confinement, deadly weapon, force, violence, fraud, bodily injury, knowingly and intentionally, were provided for you in the court's definitions of the elements of especially aggravated kidnapping and aggravated kidnapping. Please refer to those definitions here. If you have a reasonable doubt as to the defendant's guilt of kidnapping as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of kidnapping, a lesser included offense. Facilitation of a felony and kidnapping have been previously defined for you above in these instructions, and those instructions should be referred to here. If you have a reasonable doubt as to the defendant's guilt of facilitation of kidnapping as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of false imprisonment, a lesser included offense. Any person who commits the offense of false imprisonment is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant removed or confined another unlawfully so as to interfere substantially with the other's liberty, and 2, that the defendant acted knowingly. Definitions for the terms unlawful removal or confinement, force, violence, fraud, knowingly, and intentionally were provided for you in the court's definitions of the elements of especially aggravated kidnapping. Please refer to those definitions here. If you have a reasonable doubt as to the defendant's guilt of false imprisonment as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of false imprisonment, a lesser included offense. Facilitation of a felony and false imprisonment have been previously defined for you above in these instructions, and those instructions should be referred to here. If you have a reasonable doubt as to the defendant's guilt of facilitation of false imprisonment as charged in the presentment, then your verdict must be not guilty as to this offense. Aggravated rape. Any person who commits the offense of aggravated rape is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant had unlawful sexual penetration of the alleged victim, or the alleged victim had unlawful sexual penetration of the defendant. And 2, A, that force or coercion was used to accomplish the act, and the defendant was armed with a weapon. Or B, that the defendant caused bodily injury to the alleged victim. Or C, that the defendant was aided or abetted by one or more persons, and that force or coercion was used to accomplish the act. And 3, that the defendant acted either intentionally, knowingly, or recklessly. As previously indicated, counts 25, 26, and 27 of the presentment in this case charges the defendant Eric Boyd with the offense of aggravated rape by anal penetration, upon the alleged victim, Hugh Christopher Newsom, by alternative means. Counts 28, 29, 30, 31, 32, 33, 34, 35, and 36 of the presentment, in this case, charged the defendant, Eric Boyd, with 3 offenses of aggravated rape upon the alleged victim, Shannon Christian, each by alternative means. Counts 28, 31, and 34 charge the offense of aggravated rape of Shannon Christian by anal penetration by alternative means. Counts 29, 32, and 35 charge the offense of aggravated rape of Shannon Christian by oral penetration by alternative means. Counts 30, 33, and 36 of the offense of aggravated rape of Shannon Christian by the aggravated rape of Shannon Christian by vaginal penetration by alternative means. Sexual penetration means sexual intercourse, cunnilingus, fellatio, anal intercourse, or any other intrusion, however slight, of any part of a person's body or of any object into the genital or anal openings of the alleged victims, the defendants, or any other person's body, but emission of semen is not required. Cunnilingus means a sex act accomplished by placing the mouth or tongue on or in the vagina of another. Fellatio means a sex act accomplished with the male sex organ and the mouth or lips of another. Intrusion into the alleged victim's mouth is not required. Coercion means threat of kidnapping, extortion, force, or violence to be performed immediately or in the future. Force means compulsion by the use of physical power or violence. Victim means the person alleged to have been subjected to criminal sexual conduct. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, physical pain, or temporary illness, or impairment of the function of a bodily member, organ, or mental faculty. An aider and abettor is one who advises, counsels, procures, or encourages another to commit a crime. Intentionally means the person acts intentionally with respect to the nature of the conduct or to the result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Recklessly means that a person acts recklessly with respect to the circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the accused person's standpoint. If you have a reasonable doubt as to the defendant's guilt of aggravated rape as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of aggravated rape, a lesser included offense. Facilitation of a felony and aggravated rape have been previously defined for you above in these instructions, and those instructions should be referred to here. If you have a reasonable doubt as to the defendant's guilt of facilitation of aggravated rape as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of rape, a lesser included offense. Any person who commits the offense of rape is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant had unlawful sexual penetration of the alleged victim, or the alleged victim had unlawful sexual penetration of the defendant. And 2A, that force or coercion was used to accomplish the act, or B, that the sexual penetration was accomplished without the consent of the alleged victim, and the defendant knew or had reason to know at the time of the penetration that the alleged victim did not consent, and 3, that the defendant acted either intentionally, knowingly, or recklessly. Sexual penetration, force, fellatio, cunnilingus, coercion, victim, bodily injury, intentionally, knowingly, and recklessly have been previously defined for you in the definitions under aggravated rape and should be referred to here. If you have a reasonable doubt as to the defendant's guilt of rape as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of rape, a lesser included offense. Facilitation of a felony and rape have been previously defined for you above in these instructions, and those instructions should be referred to here. If you have a reasonable doubt as to the defendant's guilt of facilitation of rape as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of aggravated sexual battery, a lesser included offense. Any person who commits the offense of aggravated sexual battery is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1A, the defendant had unlawful sexual contact with the alleged victim in which the defendant intentionally touched the alleged victim's intimate parts or the clothing covering the immediate area of the alleged victim's intimate parts, or B, that the alleged victim had unlawful sexual contact with the defendant in which the victim intentionally touched the defendant's or any other person's intimate parts, or the clothing over the immediate area of the defendant's or any other person's intimate parts, and 2A, that force or coercion was used to accomplish the act and the defendant was armed with a weapon, or B, that the defendant caused bodily injury to the alleged victim, or C, that the defendant was aided or abetted by one or more persons, and that force or coercion was used to accomplish the act, and 3, that the defendant acted either intentionally, knowingly, or recklessly. Sexual contact includes the intentional touching of the alleged victim's, the defendant's, or any other person's intimate parts, or the intentional touching of the clothing covering the immediate area of the alleged victim's, the defendant's, or any other person's intimate parts, if that intentional touching can reasonably be construed as being for the purpose of sexual arousal or gratification. Intimate parts includes the primary genital area, groin, inner thigh, buttock, or breast of a human being. The terms force, fellatio, cunnilingus, coercion, victim, bodily injury, intentionally, knowingly, and recklessly have been previously defined for you in the definitions under aggravated rape and should be referred to here. If you have a reasonable doubt as to the defendant's guilt of aggravated sexual battery as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of aggravated sexual battery, a lesser included offense. Facilitation of a felony and aggravated sexual battery have been previously defined for you above in these instructions, and those instructions should be referred to here. If you have a reasonable doubt as to the defendant's guilt of facilitation of aggravated sexual battery as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of sexual battery, a lesser included offense. Any person who commits the offense of sexual battery is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1A, the defendant had unlawful sexual contact with the alleged victim in which the defendant intentionally touched the alleged victim's intimate parts or the clothing covering the immediate area of the alleged victim's intimate parts, or B, that the alleged victim had unlawful sexual contact with the defendant in which the victim intentionally touched the defendant's or any other person's intimate parts, or the clothing covering the immediate area of the defendant's or any other person's intimate parts, and 2A, that force or coercion was used to accomplish the act, or B, that the sexual contact was accomplished without the consent of the alleged victim, and the defendant knew or had reason to know at the time of the contact that the alleged victim did not consent, and 3, that the defendant acted either intentionally, knowingly, or recklessly. The terms sexual contact and intimate parts have been previously defined for you in the definitions under aggravated sexual battery and should be referred to here. The terms force, fellatio, cunnilingus, coercion, victim, fraud, intentionally, knowingly, and recklessly have been previously defined for you in the definitions under aggravated rape and rape and should be referred to here. If you have a reasonable doubt as to the defendant's guilt of sexual battery as charged in the presentment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of sexual battery, a lesser included offense. Facilitation of a felony and sexual battery had been previously defined for you above in these instructions, and those instructions should be referred to here. If you have a reasonable doubt as to the defendant's guilt of facilitation of sexual battery as charged in the presentment, then your verdict must be not guilty as to this offense. Deliberation, order of consideration. In reaching your verdict, you shall first consider the offense charged in each count number. In considering each count, if you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense, or have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within that count. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt as to the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that count, you shall return a verdict of not guilty and proceed to the next count. You shall repeat this process for each count of the presentment. Multiple counts finding on each required. The crime charged in each count of the presentment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding as to each crime charged must be stated in your verdict. Venue. The burden is upon the state to prove by a preponderance of the evidence that this offense was committed in Knox County, Tennessee. Proof by a preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by a preponderance of the evidence that this offense was committed or consummated in Knox County, Tennessee, then you must return a verdict of not guilty. Preponderance of the evidence. Preponderance of the evidence simply means the greater weight of the evidence, which is not determined alone by the greater number of witnesses testifying one way or another about the issue sought to be proved, but the preponderance is that evidence which to your mind has the greater and more persuasive force, and which you believe more closely details the factual truth. Evidence is whatever has been admitted by the court during the course of this trial for you, the jury, to see, hear, or examine. The burden of proving an issue by a preponderance of the evidence has not been met if the evidence on that issue appears to be equally balanced. You must consider all the evidence pertaining to each issue regardless of who presented it. Identity. The court charges you that the identity of the defendant must be proven in the case on the part of the state to your satisfaction beyond a reasonable doubt. In other words, the burden of proof is on the state to show that the defendant now on trial before you is the identical person who committed the alleged crime with which he is charged. In considering the identity of a person, the jury may take into consideration all the facts and circumstances in the case. The court further charges you that if you are satisfied from the whole proof in the case, beyond a reasonable doubt, that the defendant committed the crime charged against him, and you are satisfied beyond a reasonable doubt that he has been identified as the person who committed the crime charged, then it would be your duty to convict him. On the other hand, if you are not satisfied with the identity from the proof, or if you have a reasonable doubt as to whether he has been identified from the whole body of the proof in this case, then you should return a verdict of not guilty. Cause of death. Before the defendant can be convicted of any degree of homicide, the state must have proven beyond a reasonable doubt that the death of the deceased was proximately caused by the criminal conduct of the defendant, by the conduct of another for whom the defendant is criminally responsible, or both. The proximate cause of the death is that cause which, in natural and continuous sequence, unbroken by any independent intervening cause, produces the death, and without which the death would not have occurred. The defendant's conduct need not be the sole or immediate cause of death. The acts or omissions of two or more persons may work concurrently to proximately cause the death, and in such a case, each of the participating acts or omissions is regarded as a proximate cause. It is not a defense that the negligent conduct of the deceased may also have been a proximate cause of the death. If you find that the defendant's acts, if any, did not unlawfully cause or contribute to the death of the deceased, or if you have a reasonable doubt as to this proposition, then you must find him not guilty. Direct and circumstantial evidence. The guilt of the defendant, as well as any fact required to be proved, may be established by direct evidence, by circumstantial evidence, or by both combined. Direct evidence is defined as evidence which proves the existence of the fact in issue without inference or presumption. Direct evidence may consist of the testimony of a person who has perceived by the means of his or her senses the existence of a fact sought to be proved or disproved. Circumstantial evidence consists of proof of collateral facts and circumstances which do not directly prove the fact in issue, but from which that fact may be logically inferred. It is your duty to decide how much weight to give the direct and circumstantial evidence. The law makes no distinction between the weight that you should give to either one, or say that one is better evidence than the other. You should consider all the evidence, both direct and circumstantial, and give it whatever weight you believe it deserves. Credibility of witnesses. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony. If there are conflicts in the testimony of the different witnesses, you must reconcile them if you can without hastily or rashly concluding that any witness has sworn falsely, for the law presumes that all witnesses are truthful. It is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject anything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. 1. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? 2. Did the witness seem to have a good memory? 3. How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions? 4. Does the witness have any bias, prejudice, or personal interest in how this case is decided? 5. Has there been any evidence presented regarding the witness's intelligence, respectability, and his or her reputation for truthfulness? 6. Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? 7. In general, does the witness have any special reason to tell the truth or any special reason to lie? 8. All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The defendant has not taken the stand to testify as a witness, but you shall place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Impeachment of a witness. A witness may be impeached by proving that he or she has made some material statements out of court which are at variance with his or her evidence on the witness stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility, and not as substantive evidence of the truth of the matter asserted in such statements. Further, a witness may be impeached by a careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of the witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved on the trial. Expert witnesses. During the trial, you heard the expert testimony of Tim Shade, who was described to us as an expert in the field of forensic latent fingerprint identification. 2, Patty Resnick, who was described to us as an expert in the field of forensic firearms identification and examination. 3, Laura Hodge, who was described to us as an expert in the field of firearm and tool mark identification and fire debris analysis. 4, Derek Norris, who was described to us as an expert in the field of cellular network optimization engineering. 5, Randall Nelson, who was described to us as an expert in the field of forensic microanalysis. 6, Jennifer Millsaps, who was described to us as an expert in the field of forensic serology and DNA analysis. 7, Linda Littlejohn, who was described to us as an expert in the field of forensic microanalysis. And 8, Dr. Dorinka Milusinik-Polchan, who was described to us as an expert in the field of forensic pathology and anatomic pathology. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact in issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. In giving an opinion, if an expert witness testified that he or she took into consideration into consideration certain statements made by other persons. Because the statements were made outside the courtroom, the statements may be used by you only for evaluating the expert witness's opinion testimony and cannot be relied on as proof of the truth of the matters asserted in those statements unless testified to by the person who made the statement. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. Same with any other witness, it is up to you to decide what you believe is testimony and choose to rely on it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Fingerprint evidence. Fingerprint evidence has been presented in this case. You may consider this evidence in deciding whether or not the defendant is the person who committed this alleged crime. Fingerprint evidence is circumstantial evidence. There are no two people who have fingerprints exactly alike. For fingerprint evidence alone to support a conviction, you must find that the defendant's fingerprint could only have been left at the crime scene while the crime was being committed. The way to be given fingerprint evidence is a question for the jury to decide, considering all the facts and circumstances of the case. Inference from possession of recently stolen property. If you find beyond a reasonable doubt from the evidence that the property in question had been recently stolen, and that soon thereafter the defendant was in joint possession of the stolen property, this possession, unless satisfactorily explained, is ordinarily a circumstance from which you may reasonably draw an inference that the defendant gained possession through theft or had knowledge that the property had been stolen. However, you are never required to make this inference. It is for you to determine from the facts and circumstances shown by the evidence in this case whether the facts and circumstances shown by the evidence in this case warrant any inference which the law permits you to draw from the possession of the recently stolen property. When the evidence is offered that the defendant was in possession of recently stolen property, the defendant has the right to introduce evidence that he came into the possession of the property lawfully, or possession may be satisfactorily explained through other circumstances or other evidence independent of any testimony or evidence offered by the defendant. The term recently is a relative term and has no fixed meaning. Whether property may be considered as recently stolen depends upon the nature of the property and all the facts and circumstances shown by the evidence in the case. The longer the period of time since the theft, the more doubtful becomes the inference, which may be drawn from unexplained possession. The correctness of the inference and the weight to be given any explanation that may be shown by the evidence are matters that must be determined by you, and you are not bound to accept either. You must weigh all the evidence presented as to the defendant's alleged possession of the property in question and decide in light of all the facts and circumstances whether any inference is warranted. You are reminded that the burden of proving the defendant's guilt of the offense beyond a reasonable doubt remains on the state. In considering whether possession of recently stolen property has been satisfactorily explained, you are reminded that in the exercise of constitutional rights, the accused need not take the witness stand and testify. Inferences. The court has charged the jury concerning an inference that the jury may make in regard to certain evidence in this case. However, the jury is not required to make this inference. It is the exclusive province of the jury to determine whether the facts and circumstances shown by all the evidence in the case warrant the inference which the law permits the jury to draw. The inference may be rebutted by direct or circumstantial evidence or both, whether it exists in the evidence of the state or is offered by the defendant. Although the defendant is not required by law to do so, when the defendant offers an explanation to rebut the inference raised, you should consider such explanation along with all the evidence to determine not only the correctness of the inference, but also the reasonableness of the defendant's explanation. You are not bound to accept either the inference or the defendant's explanation. The state must prove beyond a reasonable doubt every element of the offense before the defendant can be found guilty. Accomplice. An accomplice is a person who knowingly, voluntarily, and with common intent with the principal offender unites with him or her in the commission of the crime. If a witness was an accomplice in the crime, then his or her testimony must be corroborated. Corroborating evidence is that evidence entirely independent of the accomplice's testimony, which, taken by itself, leads to the inference not only that the crime has been committed, but also that the defendant was implicated in it. This independent corroborative testimony must include some fact or circumstance that affects the defendant's identity. Corroborative evidence may be direct or entirely circumstantial, and it need not be adequate in and of itself to support a conviction. It is sufficient if the corroborative evidence fairly and legitimately tends to connect the defendant with the crime charged. It is a question for the jury to determine whether an accomplice's testimony has been sufficiently corroborated. In this case, the court charges you that the witness, George Thomas, was an accomplice in this alleged crime, and before the defendant can be convicted, you must find that this accomplice's testimony has been sufficiently corroborated. Evidence of other crimes. If from the proof you find that the defendant has committed a crime or crimes other than that for which he is on trial, you may not consider such evidence to prove his disposition to commit such a crime as that on trial. This evidence may only be considered by you for the limited purpose of determining whether it provides the complete story of the crime. That is, such evidence may be considered by you where the prior crime and the present alleged crime are logically related or connected, or are part of the same transaction, so that proof of the other tends or is necessary to prove the one charged, or is necessary for a complete account thereof. Such evidence of other crimes, if considered by you for any purpose, must not be considered for any purpose other than that specifically stated. Notes. Some of you have taken notes during the trial. Once you retire to the jury room, you may refer to your notes, but only to refresh your own memory of the witness's testimony. You are free to discuss the testimony of the witnesses with your fellow jurors, but each of you must rely upon your own individual memory as to what a witness did or did not say. You should not view your notes as authoritative records or consider them a transcript of the testimony. Your notes should carry no more weight than the unrecorded recollection of another juror. Deliberations. Members of the jury, some of you may have been exposed to pretrial publicity in this case. You can consider no information in reaching your verdict other than the evidence you hear in the courtroom. It would be further impermissible for you to mention during deliberations to any other juror any information that you recall reading, hearing, or seeing in the media or otherwise related to this case other than what you see or hear in the courtroom. This case must be decided solely upon the evidence that you hear in the courtroom. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case outside the jury deliberation room. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. If you find from the proof beyond a reasonable doubt that the state has proven the defendant guilty of the charged offense or any lesser included offense in each count of the presentment, you will so report on the appropriate verdict form that will be provided to you. On the other hand, if you find the state has not proven the defendant's guilt beyond a reasonable doubt, or if you have a reasonable doubt as to the defendant's guilt of the charged offense and the lesser included offenses in any count of the presentment, then your verdict must be not guilty as to that offense. You will be provided with forms which list all possible verdicts in this case and which specify the alleged victim and the specific charges alleged for each offense. For each count, the jury will check the appropriate verdict on the form, and your foreperson will sign the form. The verdict forms which you receive, they follow. The verdict forms are attached, and you'll be able to read them. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations. When you have reached verdicts, you will return with it. When you have reached verdict, you will return with it to this courtroom, and your foreperson will deliver them to the court. You must not imagine that the court has any opinion in regard to the facts. It is your duty to find them, and I have attempted to read this charge so as to define to you the law without indicating any opinion about the facts whatsoever. Members of the jury, the presentment in this case is herewith handed to you, together with the charge, the exhibits in this case, and the verdict forms. In just a moment, you may retire and consider your verdicts. On page 4 of the instructions, 1, 2, 3, 4, the fourth line down, reference is made to the number 12. In parentheses is the number 10. Number 10 is correct. 12 was a typo. I'm going to strike it and initial it on these instructions. And you can do the same on your stick. All right, ladies and gentlemen, as you can see, there's 16 of you. Under Tennessee law, only 12 people can deliberate to reach a verdict. So each of your names is printed on a small piece of paper and it's up. I'm going to shake them around and pull out 4 names. These 4 people will be excused. and we thank you very much for helping us. Since we've been working in here for about 4 hours, none of us have the slightest idea what the weather is. I hope it's pleasant for whoever these for. All right, ladies and gentlemen, it's time for you to take the case. Please go with your court officer. Get started. All right, you can be seated, and we'll be in recess. Any matters kind of wish to take up at this time? We'll be in recess till we hear something from the jury.